So let's re-silence it. My name is Joyce Daniels, and it's my honor and privilege to be start off with the indefatigable, elegant, and consistent chairman of the Chartered Institute of Arbitrators, Nigeria branch. Please let's welcome together Mrs. Adeboyin Rose Viral.
Thank you very much, Joyce. Good morning. The Honorable Chief Justice of Nigeria, Justices of the Supreme Court here present, distinguished members of the National Assembly, the Attorney General of the Federation, Mr. President of the Chartered Institute of Arbitrators, our visitors from around the world, heads of professional organizations, distinguished ladies and gentlemen. I'm most delighted to welcome you on behalf of the Chartered Institute of Arbitrators, Nigeria branch, to the 2018 annual conference. Now, who is the Chartered Institute? The Chartered Institute of Arbitrators is the internationally recognized home for arbitrators and alternative dispute resolvers. Our institute, an international organization with branches in over 133 countries of the world, is considered worldwide as conferring the gold standard in arbitration education and training. When I first started in arbitration in the 1980s, and we go to all these international events, at that time there was every institution offering high standard arbitration training in Nigeria, apart from the work of the United Nations Center for Transnational Cooperation, who worked hard with the Federal Ministry of Justice. There was hardly anybody else. And then when we go abroad, we're only hearing about two names in the arbitration field. In fact, when they see you from Africa, they have to ask you, do you know Mrs. Oyekunle? Do you know Principal Ajibola? That was how it was then. And even then, you find disputes between two African countries being arbitrated by an arbitrator from outside Africa. You hardly found African practitioners on the international arena. But now, due to the work of the Chartered Institute, I can say that we have many international arbitrators of international repute, well known on international tribunals all over the world. Our qualifications are a mark of distinction in the field of arbitration. Our ethics are regulated by the CIArb Code of Conduct. The Institute is eminently regarded as the world's leading center of excellence for the promotion and facilitation of dispute resolution. The Institute collaborates with professional organizations worldwide in its mission to spread the gospel of arbitration and ADR and assist parties resolve their disputes expeditiously and effectively. We were established in 1915, over 100 years ago, to provide a membership organization for arbitrators with a view to raising the status of arbitration to the dignity of a distinct and recognized profession as one of the learned professions. I believe, and I'm sure you all agree, that the Chartered Institute indeed has achieved that vision. The vision of its founding fathers, can I clap for myself? The vision of its founding fathers has been actualized today, and today the Institute has a growing membership composed of 16,000 members across 133 countries of the world, and it's supported by an international network of 40 branches across all continents of the world. There are 5 branches in Africa. We have Kenya, my Kenyan brothers and sisters are here. We have Mauritius, we have South Africa, Lawrence is supposed to be here, I don't know whether I get that right. We have Zambia, my Zambian sister, the chairman of the Zambian branch is also here. And we have the Nigeria branch. We are all here, our past chairs are here. Our institute, and I repeat, our institute does not compete with other arbitral bodies in nowhere else in the world. And I don't want to enter into any sort of stories today. But I can tell you that there's nowhere else in the world, as it is said, that the institute competes. We work with all arbitration institutions. We collaborate and work with them, with all institutions, domestic and international, as long as they have similar objectives as ours. That is to raise the standard of arbitration to ensure that arbitration and ADR can effectively work with the judiciary to contest just because, to ensure that our judges are no longer overworked, because Nigerian judges are overworked. And I'm not sure that they are on that page. The Nigerian branch is one of the global body's fastest growing branches. The President has told me tell more about what the Nigerian branch has achieved. The branch was granted branch status by headquarters in 1999, nearly 20 years ago. And I remember when we were working towards the branch, Mr. Jide Ogundike is here. He was the one that wrote the first letter, working with Mr. Oyetunde, to all of us who were listed in London, that we should start meeting so we can be accorded branch status. Presently, the branch has chapters in Abuja and Port Harcourt. This event is being hosted by the Abuja chapter. They have done very well. Chapters provide our members with additional localized and specialized opportunities in pursuit of our mission to spread the gospel of arbitration and ADR. Our body membership of over 1,000 members avails users a choice of highly trained and experienced alternative dispute resolvers of international repute. Our members are represented on the major international arbitration institutions and organizations, including the International Center for Settlement of Investment Disputes, ICSID, headquarters in Washington, D.C., the International Chamber of Commerce, International Court of Arbitration, Paris, the London Court of International Arbitration, London, the International Council for Commercial Arbitration, ICA, and the Permanent Court of Arbitration, The Hague, the Netherlands. Our branch is committed to advocating a conducive environment in our jurisdiction for the practice of alternative dispute resolution. We continue to play a pivotal role in having an up-to-date legal framework. We work with our legislature and other stakeholders on the reform of the Arbitration and Conciliation Act, aimed at removing from Nigeria's statute books the current act, which is based on the 1985 Municipal Model Law and the 1976 arbitration rules. And we've been working very hard to have a statute based on the 2006 Municipal Model Law, which is now the international standard, and the 2010 Municipal arbitration rules, thus further bringing Nigeria into the realm of countries with an up-to-date legal framework. At this stage, I must commend Nigeria, because we were the first country in Africa to have adopted the Municipal Model Law. I'm also happy to state that on the first day of February 2018, the Senate passed the Arbitration and Conciliation Act, Repeal and Enactment Bill 2018, and forwarded the bill to the House of Representatives for concurrence. Though there are still legislative and executive steps to be taken before the law is passed, this indeed is an achievement, one we've been working on, I think, for the past 4, 5, maybe even 10 years, when Chief Bayojo, trustee for Africa, first constituted a committee headed by the late Honorable Justice Orojo to look into Nigeria's arbitration laws and formulate proposals for its amendment. Now, I come to also a very important aspect of our work, which is training. The Chartered Institute focuses on arbitration and training. As I said, we are not in competition with other arbitral bodies, but collaborate with organizations which have similar objectives with ours. The Chartered Institute's qualitative training has received various commendations. The School of Oriental and African Studies, SWAS, Emilia is here. Emilia has done a lot of work in this field. University of London Arbitration in Africa Survey gives further independent support to the work being done by the Chartered Institute in the field of qualitative training for arbitrators. Based on confirmed data and statistics, the SWAS survey identified the Chartered Institute as the primary arbitration training provider in Africa. In his inaugural speech made on the 12th day of January 2018, the president of the CIArb, Mr. James Bridgman, SC, CIArb, emphasized the important role of the CIArb, the premier private dispute resolution professional body, has to play in the establishment and maintenance of standards of excellence and constant improvement in both international and domestic dispute resolution. The CIArb continues to build on the efforts thus far, and we recently launched our new Training Pathways program. The new pathways. The delivery of education and training qualifications is an integral component of the CIArb's golden thread.
the CIArb internationally recognized training, which confers on successful participants the right to use the world-renowned post-nominal letters, is constantly being updated to ensure the maintenance of the highest quality standard across the education plane. And I just want to mention something that my president said yesterday, to just let you know what the CIArbs, those post-nominal letters are worth. In most jurisdictions, people are reluctant to appoint first-time arbitrators to disputes. But when they see that you have the qualifications of the CIArb by their name, they go ahead, they appoint you, because they know you've gone through a very stringent and grueling training program. However, we are still updating ourselves. We are not resting on our oars. A review designed to revise and update all pathway training and assessment to ensure consistency, fairness, standardization, and rigor across the training and education plane is being implemented. The rollout of the new pathways and the associated new centralized assessment system is underway in United Kingdom, Europe, Asia Pacific, and was introduced in Africa in March 2018. Part of the reasons for this is to make sure that there's standardized training all over the world. So if you are undergoing your training in Nigeria, in England, in America, they want to ensure that it's of the same standard. The approved faculty list of tutors is an integral mechanism to ensure a faculty of highly trained resource persons. Regional pathway leaders have been appointed across the globe with the responsibility of ensuring that the respective regions' approved faculty lists are fully trained in the new models, and that their teaching and presentation skills continue to meet the standard and quality commensurate with CIArb's reputation and aspirations. The role of the newly appointed RPRs are to train the trainers, review and support them in maintaining or developing their respective skill and approaches. Trainings have been held for RPLs worldwide. The training for Africa's regional pathway leaders, the Nigerian crop, was held in Nairobi, Kenya, on the 27th to 29 days of March. The CIArb training, including its specialized training for the judiciary, is second to none, as I'm sure all of you gathered will attest. Judicial support. A supportive judiciary is essential to the continuing efficacy of arbitration as an effective and attractive dispute resolution procedure. The support of the judiciary is required prior to the process, during the process, and after the resultant award has been delivered. The international standard requires the support of the judiciary and prohibits judicial interference except as specifically provided in the relevant statute. I'm glad and I'm happy and delighted to say that Nigerian courts largely support arbitration. They affirm the principle of non-intervention, which they have done in several judicial cases, as several judicial authorities affirm. Several courts have also established multi-door courthouses, offering court-connected ADR, and thereby making available alternative doors for dispute resolution. This has been done at the Court of Appeal. There's opening of the Abuja Federal Capital Territory Court Mediation Center this morning, and which is why I'm sure our Attorney General will have to take his leave shortly. In my speech at the opening ceremony of the 2017 annual conference, I made reference to the pronouncement of the Chief Justice of Nigeria, Honorable Justice Walter Samuel Nkanu Onogen, GCON, in which he prohibited courts indulging parties who, in breach of arbitration agreements, commence litigation proceedings, or the utilization of the court system to frustrate otherwise legitimate arbitration agreements and the resultant awards. Recently, again, the Chief Justice of Nigeria encouraged the use of ADR as part of the mechanism put in place to resolve asset-related disputes. Indeed, the Nigerian judiciary is supportive of arbitration. When an investor wants to invest in a foreign country, the first thing he wants to know, what kind of laws do they have for alternative dispute resolution? Do they have a model law-based arbitration law? Do their courts support arbitration? If he receives the answer no, he's going to be very reluctant to come into your jurisdiction. We all know how much Nigeria requires for indirect investment. The CIArb calls on all stakeholders to adhere to the international principle of non-intervention in arbitral proceedings and respect for international dispute resolution. In particular, lawyers lawyers as officers in the temple of justice, are obliged to uphold and observe arbitration agreements validly entered into, respect the process, and observe the highest standards to maintain Nigeria's perception in the international dispute resolution plane. The CIArb appreciates judicial and executive support for its work. Presently, the CIArb is working on instituting a working group of African countries. That's headquarters. We want to institute a working group of African countries with a view to organizing a roundtable on international arbitration. We want that working group to be composed of judges and justice ministers from both the civil and common law traditions, with a view to further discussing on the way forward, including the harmonization of the common and civil law legal traditions that exist within our frontiers. We look forward to the support of the judiciary and justice ministers in our project. Judicial support to the work of the CIArb in dispute resolution is essential. Given the years of experience of our judges on the art of judging, irrespective of the difference between judgments and awards, together we can bring our respective skills to the arbitration and ADR community and further decongest our courts. Our 2018 annual conference. The theme for our 2018 annual conference, Arbitration and ADR in Africa, Challenges and gains and lessons for the future, is focused on contemporary frontline issues in arbitration and ADR in Africa. The topics have been carefully chosen to give insight to the challenges facing the development of arbitration in Africa, the gains we have achieved, and the way forward for arbitration in Africa. The conference gives us the opportunity to ask ourselves questions, to learn from the experience of other jurisdictions, and to assess our capability and capacity in the field of international dispute resolution. Are there any specific problems militating against the use of ADR as a tool of economic development in Africa? Do we have adequate infrastructure? Is our government doing enough to make our countries attractive for arbitration? Does the government appreciate the invisible earnings that the country stands to earn from international arbitration? Does our legal framework meet international standards? Are we building up our arbitral institutions? Are we effectively using mediation in the settlement of disputes? Should there be more collaboration between African arbitral institutions? Are our practitioners represented in the international arbitration plane? Those are a lot of questions, but they are all important. Indeed, a lot of initiatives are being put in place to address some of the concerns, militating against the optimization of the benefits of ADR to African countries. Members of the Chartered Institute continue to play a key role by giving of their time and resources to the various initiatives. We are most appreciative. I know the number of times our members travel all over the world, and some people think they are being paid for their time and their money, but they are not. We use our own resources to ensure that we can further the goal of promoting Africa and African practitioners in the international arena. A series of consultative workshops were organized under the auspices of the International Council for Commercial Arbitration, headquartered at The Hague, the Netherlands, with the goal of promoting the use and development of international arbitration in Africa. The workshops were held in Mauritius in 2016, Cairo in 2017, Abuja 2017, and Kigali 2018. Recognize the need of fostering better cooperation among African arbitral organizations and working towards the establishment of an umbrella organization dedicated to the promotion and development of international arbitration and arbitrators in Africa. The launch of the African Arbitrators Association is the culmination of the years of preparatory work by ICA, arbitral organizations in Africa, and various individuals, many, in fact, most of them, members of the Chartered Institute. The AFAA was launched at the headquarters of the Africa Development Bank in Abuja, Côte d'Ivoire, was born out of the need to promote Africa and African arbitrators in the international arena. The objectives of AFAA, headquartered in Kigali, Rwanda, they are here. Fidel Masengo is here from Kigali International Arbitration Center. That's where the AFAA will be headquartered. Includes enhancing the capacity of African parties. Let them be bold enough to be able to know they can actually choose the arbitrators, that there's a pool of African arbitrators, that when they're on those international panels, that they have a voice. They don't have to be timid. Africa has come of age. Institutions and practitioners, facilitating and encouraging the appointment of African international arbitration practitioners and strengthening the legislative and judicial framework in the field of arbitration in Africa. Chief Baojo is here. He's the president of the AFAA. Thank you, Chief, for all your efforts and your work. Indeed, Africa has come a long way, though our work is not yet done. Gone are the days when there was hardly any African representation on the international arbitration arena. Wide-scale capacity building programs aimed at developing the knowledge of Africans in the field of international arbitration has assisted in producing many good and skilled African arbitrators. The CIArb has been very instrumental in the increased number of African arbitration practitioners, and the AFAA intends to continue working with the CIArb in building the capacity of African arbitrators. The International Chamber of Commerce, International Court of Arbitration, just to let you know that indeed Africa has come of age. Everybody is taking notice of Africa and doing what they need to do to support us. The International Chamber of Commerce, International Court of Arbitration, has recently set up an African Commission. Because when they want to appoint arbitrators, if they don't have African arbitrators on their list, if they don't have African arbitrators that they are sure they have the capacity and the capability and the right ethical values to do the work, they're not going to appoint us because they don't want to tarnish the name of a reputation of an institution that has been built over the years. But they are now working. They've set up an African Commission whose task is also to be able to identify suitably qualified and trained arbitrators, African arbitrators that can be appointed to disputes. The next 2 days provides the opportunity to discuss, identify challenges, and prefer ways to advance arbitration in Africa. Our hope is that we can all together place Africa on the world map of arbitration to meet the standards of the traditional centers. London, Paris, New York, and the successful emerging centers like Singapore, within a very short time, Singapore rose up to be very well recognized because they took the right steps. They put in the right laws. They amended even their Legal Practitioners Act to ensure that they specifically provided that you don't have to be a lawyer to be a counsel in international arbitration proceedings. And they've emerged, they're recognized. Disputes are being seated in Singapore very frequently. Then we have our African centers who are also rising to the task. Cairo, Kigali, Nairobi, and the Lagos centers are rising up to the challenge. We must learn from the efforts of the established arbitral institutions, Paris, London, and recent centers like Singapore, and continue to work relentlessly towards building and maintaining our African centers. And before I go to finally, I want to talk about the ERA pledge. Diversity is very important in arbitration. We all know that in arbitration, different parties are involved. So we must have a diverse pool. We must have ladies. We must have men. We must have the younger generation. So there's a lot of efforts being made to ensure diversity in international arbitration. And then we have the ERA pledge, which was recently launched to address the problems of the underrepresentation of women in international arbitration. The ERA pledge is not the end. It's just a first step to ensure diversity in all its gamets is addressed. At this conference, we have a diversity stand. Please, I would be grateful if participants could visit that stand and sign on to the ERA pledge. The CIArb was one of the first international organizations to sign on to the other pledge. Sign on to the ERA pledge to show your support for diversity in international arbitration. Finally, I commend all those who have made this conference possible, either through their financial support and other various resources, including their time. We are grateful to our members who assiduously commit their time and resources to the work we do. May I mention particularly my colleagues on the executive committee. They're all here, except for one or two who had to travel, or 3 or 4, who are presently away on international arbitration assignments. Members of staff of the Secretariat, under the leadership of our General Manager, and then the Conference Planning Committee, headed by Honorable Shola Uluwanuga. I thank you all. And then members of our various committees and our approved tutors who do all that work. I welcome you all to the 2018 Annual Conference of the Chartered Institute and wish you 2 days of insightful and enlightening discussions, concluding with our gala night, when our new members will be inducted and we can all take time to rise together in Abuja, the Federal Capital Territory of Nigeria, the center of unity. Thank you very much, ladies and gentlemen.
Thank you very much, our very thorough Nigeria branch chair, ensuring that we all know where we are up to speed. Please, if you would once again appreciate Mrs. Adedoyin Rhodes Vival. For his opening comments, please let's welcome the Honorable Attorney General of the Federal Republic of Nigeria and the Minister for Justice, Mr. Abubakar Malami, Senior Advocate of Nigeria.
My Lord, the Chief Justice of Nigeria, Justice Walter Onoge, the President of the International Chartered Institute of Arbitrators, the President of the Chartered Institute of Arbitrators, Nigeria, my Lords, the Justices of the Supreme Court here present, my learned brother Silk here in attendance, and my predecessor in office, Mr. Bayo Ojo, distinguished participants, local and international, ladies and gentlemen. I'm most delighted to welcome you all to this year's conference of the Chartered Institute of Arbitrators Nigerian branch, which is a leading professional membership organization representing interest in alternative dispute resolution practitioners globally. The theme of this year's conference, Arbitration and ADR in Africa, Challenges, Gains, and Lessons for the Future, is indeed timely. Africa, and of course Nigeria, is moving away from the traditional court system of dispute resolution and fast embracing arbitration and other forms of alternative dispute resolution mechanisms which are considered more efficient. Parties to arbitration ab initio agree to it and can choose their arbitrators. They are also expected to accept an award as binding and enforceable immediately it is rendered. Generally, there is no intention of further prolonging the dispute or reports to court once an award is made. However, as is the case with other human endeavors, it does happen that a party may have a good cause for not wanting to accept or abide by an award. In that case, such a party is afforded an opportunity of challenging the award through judicial process. An arbitrator does not possess the power of the court or the wherewithal to enforce an award, and that it is inevitable and even desirable given the advantages accruing from the application of the time-tested economic principles of division of labor. This surely calls for the inevitable involvement of court and even other law enforcement agencies. It is true that enforcement of award is done by the court. However, execution of the award is the function of the sheriff, since the sheriff cannot act without direction of the court. The need for application to the court for enforcement and consequent execution of award arises. Except a court is seized of an application for setting aside an award or an enforcement of an award in a situation where there is a pending application for enforcement of an award, stay of execution cannot issue whether of monetary or non-monetary awards. Oftentimes, the interplay of these issues affect the efficacious enforcement of arbitral awards. The success of enforcement of foreign awards is essentially hinged on the mastery of the court procedural rules. Nigerian courts take the procedural requirements seriously as they are meant to be obeyed. It is thus important that any party requiring recognition and enforcement of foreign arbitral awards be aware of the national procedural rules that will apply to its award. The New York Convention, which is the most important and successful United Nations treaty in the area of international trade law and the cornerstone of the international arbitration system, was put together to facilitate the recognition and enforcement of foreign arbitral awards in member countries. The Convention's principle is aimed to oblige state parties to ensure non-discrimination of foreign and non-domestic arbitral awards such that these awards are recognized and generally capable of enforcement in their jurisdiction in the same way as domestic awards. It is cheering to note that Section 54 of the Nigeria's Arbitration and Conciliation Act recognizes the New York Convention, and we should seek to maximize its application under Nigerian law. The foregoing said, more needs to be done to enhance Nigeria's rating in the Committee of Arbitration-Friendly Countries. Reference must be made to the 2016 ICC dispute resolution statistics, where out of 187 arbitration cases involving African parties, only one was resolved in Nigeria. Nigeria must also pay attention to factors that influence the choice of arbitral seat, such as the track record for enforcement of arbitration agreement and awards, neutrality and impartiality of legal system with up-to-date arbitration laws, and availability of specialized lawyers and arbitrators familiar with the seat and modern facilities. The legislative role expected of the executive by way of giving assent to relevant arbitration bills is assumed when the time comes for the assent. The above highlighted issues are just to set tone for the discussion at this conference, as there are other important issues and challenges facing arbitration practice in Nigeria, which I believe this conference will discuss and proffer solutions to in order to bring the desired change in the arbitration practice in Nigeria and Africa at large. I wish you successful deliberation at this conference. Thank you very much.
Our most sincere gratitude to you, sir, for being here and for letting us know where Nigeria fits into all of this in the arbitration space. Please let's together appreciate the Honorable Attorney General of the Federation and Minister for Justice. Thank you, sir. We have a goodwill address by our special guest of honor, the President, Chartered Institute of Arbitrators, who is here very comfortably seated and looking gaily dressed. Please let's welcome Mr. James Bridgman as he comes to the microphone. Welcome, sir.
Good morning, thank you very much. Good morning, Mr. Chief Justice of Nigeria, the honourable members of the Judiciary, Mr. Attorney General, brothers, sister members of the Chartered Institute of Arbitrators, friends and colleagues. I'm delighted and honoured to have been invited here by the Nigerian branch to give this goodwill address today and to participate in the conference, and to participate in yesterday's Young Members Conference as well, which is very important in our institute. I would like to thank you for the invitation, and I would like to thank the Nigerian branch and all of your members of the Nigerian branch who are here for the work that you put in and for your contribution to the Institute and to arbitration in Nigeria and in the world. The Nigerian branch is a very important, it's very large, and it's a very valued element within the Chartered Institute of Arbitrators. And as you've heard this morning, it is a very important machine within Africa in the development of private dispute resolution. And it's playing a part, it has played a part, and will continue to play a part in the development of private dispute resolution across the continent and the wider world. The Chartered Institute of Arbitrators is a very large international organisation. We have 16,000 members. We're in 40 countries. And we are engaged in private dispute resolution in arbitration, in mediation, in construction adjudication, in dispute boards, in various forms of private dispute resolution. And in order to achieve the level of excellence which we aim at, the committees within the Institute have developed the pathways, a training program to achieve excellence, to achieve global standard in training, in qualification for neutrals and for other people who are involved in the process. Now, this year when I became president, I was asked to pick a theme for the year. And the theme which I chose to pick for the year was quality assurance and ethics in international arbitration. The theme for your conference is challenges, gains, and lessons for the future. And as I looked at the challenges to arbitration internationally, not only in international arbitration, but in domestic arbitration, one theme came through for me, and that was that most of the criticisms of the procedure and most of the areas where the procedure could be improved had an ethical basis and related to independence and impartiality, related to transparency, and related to the demand for diversity, which wasn't being fulfilled to the level of expectation of the community ourselves and for the wider stakeholders. So for that reason, I've asked to put an emphasis on these themes. And particularly to talk about diversity, if I may, because I don't want to take up the whole morning, but in diversity, one of the consequences of increasing the diversity of arbitrators, mediators, and adjudicators is that new people have to be given an opportunity. And that means somebody has to take a risk. And the chances are that the parties won't take a risk. And the chances are that the lawyers won't take a risk. So the risk will have to be taken by the institutions. It's the institutions that will have to give people their first break. It's the institutions that will have to look and say, well, you know, this is somebody who can do the job. And it's the institutions that will have to be answerable in our statistics to show that we are moving in that direction. So my message to the institutions and to the state in Nigeria, everywhere, around the world, the international arbitration institutions, the domestic stakeholders, is that we can help this diversity, because when there's a risk, that risk can be managed. And the risk in trying new people can be modified by selecting somebody who we are confident will be able to do the job, even if she has never done it before. And how do you do that? Well, you do it by training, you do it by assessment, you do it by qualification, you do it by continuous professional development, you do it by regulation, and you do it by support. And we in the Chartered Institute of Arbitrators have these pathways, and have associate, member, fellow, chartered arbitrator, have these grades of qualification that are a badge of that ability to do the job. And in the most unlikely event of somebody not doing the job properly, we have a regulatory disciplinary process which operates within and outside of institutional arbitration, that operates in ad hoc references where the major risk would probably be. So for that reason, my message is that if you want to appoint a new person to arbitration, or want to appoint somebody who is experienced into maybe a more complex form of arbitration, or move somebody from domestic arbitration to international arbitration, and you take the risk, you're reducing your risk and you're avoiding criticism by choosing a member of the Chartered Institute of Arbitrators. And that's really been my message to the international community. Africa will look at its own challenges. Africa will look at its own lessons. Africa will look at its own future. And the future of Africa is in the hands of Africa. The future of Africa is especially in the hands of the young people of Africa. And we can play a part in that by the encouragement which Mrs. Rhodes-Vavour and her team, which Chief Bayo Ojo have given to the young members, and the continuing support which is being given to our existing members in developing our skills, in maintaining our skills through continuous professional development, and through increasing our skills by stratified levels of training. So I'm hoping that the African community engages more in the international world as well. And one hope that I have is that the young people of Nigeria and other African countries will involve themselves in the moots, in the Vismoot, in the international moots, and have teams in these international moots, because it's there that the presence is felt. And these are very important events in international arbitration, and they give the participants an understanding and a connection and a network to build that future. So thank you once again for the invitation. I would like to congratulate your team for putting on this magnificent conference. And on behalf of the members of the Chartered Institute of Arbitrators, I would like to thank all of you people who have arrived here today for your support for the Chartered Institute of Arbitrators and our work. Thank you.
Thank you, Mr. James Bridgman. Please, could you just raise your two hands and look at them? Just look at your hands. Look at your hands. Oh, your own hands, not mine. Look at your hands. And say, the future of Africa is in these hands. Oh, I'm sorry, please. If you're young, please say it. Because it's in the hands of each and every one of us, and he has just reminded us that nobody else is responsible but who? But us, you and I, to ensure there's transparency, diversity, and we manage the risks effectively. Once again, please let's appreciate the President, CIArb, Mr. James Bridgman. Thank you, sir. To give us an overview of the conference, what to expect today and tomorrow in detail, we have the Chair, Conference Planning Committee for this year. Please let's welcome together Mr. Shola Ephraim Oluwanuga, MNI, FIOD, and Fellow of the Chartered Institute of Arbitrators. Welcome, sir.
Thank you very much. My Lord, the Chief Justice of the Federation, permit me to lean on the existing protocol because of time. On behalf of the Conference Planning Committee of the CIArb 2018 conference, I welcome you all to the city of Abuja, Nigeria. The CIArb conferences are excellent opportunities for networking and catching up with new trends and developments in the arbitration terrain and strategizing for improvement in arbitration and ADR practices. The chairman of the branch has aptly captured the benefits derivable from the conference and the undeniable mileage it will give African arbitrators, users, and countries. I do not intend to overflog these issues. The conference has been made particularly interactive to stimulate discussions and help profiling strategies to assist Africa, particularly Nigeria. At this conference, we want to make sure we address your most burning questions. Therefore, we'll be using a simple audience interaction platform called Slido. Slido allows you to submit your questions as well as upvote the questions of other participants. Questions with the highest number of votes will stand a better chance to get answered by speakers. Throughout the conference, you will also be able to express your opinion by voting on live polls. So, ladies and gentlemen, could you kindly bring out your phones, please, if you don't mind? Bring out your smartphones. Connect to Wi-Fi. As you can see on the screen, the Wi-Fi name for this conference is CIArb 2018, and the password is CIArb NG12, all lowercase. I haven't done that. Open the web browser on your device. Go to www.slido.com. and enter the event code, which is #CIARBNG. Let's continue. We also prepared a warm-up poll for you to help you get familiar with the platform, as well as to find out your main reason for joining us today. In the poll, please tell us, why did you decide to join the event today? Knowledge building? Is it networking? Opportunities? Speaker lineup? And so on. Or your boss made you join us? I can see that 71% of those of us here came because of network opportunities. It is our hope and desire that the body of knowledge generated at this conference will serve as a veritable tool for policy formulation, for arbitration practitioners and users, as well as the academia in the future. We have liaised with the NBA to ensure that in addition to the CIArb, participants will get CPD points for attendance. Also, you will have questionnaires. You have a set of questionnaires in your bag. Kindly fill it and hand over to the ushers before the end of the program. In the midst of all this, we hope you will find time to experience a bit of Abuja tourism potentials. We trust that this will be a good quality conference and it will be one without a difference. Only yesterday, you had a stream of the YMG program to all the conference delegates. I can assure you that after today, at least the opening ceremony will be streamed all over the world. Thank you very much for the opportunity to come for this conference. Bless you.
Thank you so much, Mr. Shola. I would ask you quickly to please join others who are up here for a group photograph before we move into the next session. Please, could we appreciate all our distinguished personalities up here? Yes, please.
Don't let this fall down, please.
And just before the pictures are taken, there's a presentation to be made by our chairman. Please direct them on where exactly you want them to stand for best. Forward or right there? Okay. Please smile. It's okay. James Bridgman. James Bridgman. When he finishes. Oh, this was just for James. They are not putting on that. So, Ma, please, we need to centralize just a little bit. And Mr. Shola, you stand by her side. Okay, to support. Thank you. And before we move into the next session, of course, Mr. James, our president, and our Nigeria chair are going to take their seats comfortably off the stage. The next session promises to be a highly engaging and stimulating session where we would have a discussion listening to the thoughts of the Chief Justice of Nigeria. But to stir the conversation, please let's together welcome upstage Member Board of Trustees, CIArb, and Regional Trustee for Africa, Chief Adebayo Ojo, Senior Advocate of Nigeria. He would come up to engage the Chief Justice in this productive discussion for all of 1 hour and a few minutes.